Hi, everyone. As Ali said, my name is Rebecca DiNucci. I'm one of the attorneys here at Anderson Elder Law. And today we're going to focus our attention on living wills and advanced directives. They truly are the most important documents you will ever sign. Um, why does this matter? So generally it's kind of an unpleasant thing to think about. Thinking about who you want to make medical decisions for you if you are unable to make those decisions yourself is something most people put off. They feel like they can do it another day, another time. They feel like there's always time for it. And I think there's various reasons why people do that. Sometimes it's just hard to choose between potential decision makers. Sometimes it's hard to trust anyone to make these decisions. But truly, by not thinking about it and not making a choice, you are making the situation so much more difficult for your families. Accidents, illness can happen at any time, at any age. So the time to think about it is now and get these documents done. If you don't, the result is family members or decision makers are left guessing. It can make what is already a very stressful time even more stressful. By not having a clear healthcare power of attorney and living will, the decision makers don't know what you would want. This results oftentimes in disagreements among siblings. When I talk to people, sometimes they're like, "Oh, my kids get along, everything's great." And that might be true now. But if you haven't taken the time to do these documents, even siblings who do get along and have the absolute best intentions might remember conversations a little differently and truly believe they are doing what you want. But that doesn't prevent the strife between family members. A lot of times when we have consultations with people, one of their goals in doing all of their estate planning documents, their wills, financial power of attorney, healthcare power of attorney, living will, is to preserve family harmony. The best way to do that is to have your wishes clearly stated and to have the decision makers appointed. By not having the documents, it also can cause a delay in care decisions. This can be caused by uncertainty, indecision, or arguments between decision makers. Worst case scenario is always when the court has to get involved. This is relatively uncommon, but it does happen. I think everyone here probably remembers the case of Terry Schiavo. This was back, it started in the 90s, it went on to the early 2000s, and it was back and forth for years arguing about whether to take her off life support. Um, she didn't have any documentation, so there was a lot of arguments about, had she ever expressed what she would want in an end stage vegetative state. This sticks with me. I was a child when this was happening, so it like really made quite an impression on me. It was all over the news, and I remember being like in middle school writing my own living will out by hand because it was all over the news. And even at a young age, I knew what I wouldn't want. So for a lot of people, the publicity of that situation, it was just um, it was just covered by every news outlet at the time. Is when people really realize the importance of having these documents. The next slide, the goal of these documents. The goal is to choose a decision maker and then also choose the backup. So it's not just choosing one person, it's also choosing someone in the event that that person is unwilling or unable to serve for whatever reason. Also, make your healthcare wishes known. By doing that, it will reduce the burden on your loved ones and avoid unnecessary conflict. So often, I have appointments with people who just went through a very traumatic health event with their parents, who didn't have the documents in place. And they say to me, "I never want to put my kids through what I just went through with my parents." So, cautionary tale, just get your documents done now while you can and just save your family all that unnecessary heartache and stress. Um, there's really two key documents when we're talking about healthcare choices and healthcare wishes. It's the living will and your healthcare power of attorney. Sometimes people confuse them. They're really two distinct separate documents, but sometimes they're combined into one document, but they each have a distinct function. The living will outlines your medical wishes if you have an end stage medical condition or you're permanently unconscious. It applies only when you cannot communicate your wishes. So you can be end stage, you can be death is imminent, unavoidable, but if you can communicate your wishes, the living will does not come into effect. The living will focuses on life-sustaining treatment. For example, would you want a ventilator? Do you want feeding tubes? Would you want resuscitation? In the situation where you are truly end stage and the application of these treatments will not change the outcome. The decisions you're making when you're looking at this document is the decision on comfort care versus aggressive treatment, even if the outcome will not be changed. The healthcare power of attorney, on the other hand, names someone to make decisions for you in the event you're unable to make your own medical decisions. So this comes into play even before your end stage. So you could just be, under anesthesia or just for temporarily unable to make your own medical decisions. And you need to have someone who has standby authority to jump in, make your decisions for you. This can really cover a wide range of medical situations. By naming your agent would be able to speak to your doctors, make treatment decisions, access your medical records, and be your advocate. This is why, though, it's so important that your agent actually know your wishes. Your agent is not supposed to substitute their wishes for yours. This is why it's really important to have the conversations with your agents about what you would or would not want. I had a situation where a client had had conversations with her surrogate decision maker, had said, I absolutely do not want, under any circumstances, amputation. It came down to a point in the future where the healthcare agent was called in to make this decision. The healthcare agent himself would have, if it was his choice, have gone forward with the amputation. But because they had had these conversations, he knew what her choices were and he followed her wishes. I've recommended in my any other presentation that you explore the website. It's called the Conversation Project. You can Google it. It specifically helps people have these conversations about the care you would want or not want if you have a surrogate decision maker making those decisions. It can feel really awkward to have these conversations, and people always feel like they have more time to do it. But this website, I think, is a great resource for you to look at, and then, it might help push you to have these discussions with your family members. The living will, so to kind of summarize, the living will, what do you want? And the healthcare power of attorney, who is actually making the decisions. And again, the living will only applies in very limited circumstances. You still need someone to make medical decisions for you in other situations other than when you are truly end of life. Now, people say, well, what if I don't have a healthcare power of attorney? Well, Pennsylvania law in Act 169 provides a chain of command as to who can make your medical decisions. The law establishes a hierarchy for who can step in and serve as your healthcare representative. The hierarchy in Pennsylvania is the spouse and adult children if they're not the spouse's children. So in the case of a blended family, then it would be adult children. After adult children, it's parents, then adult siblings, then adult grandchildren, and then finally a close friend who might know your wishes. So sometimes people see this and they're like, well, great, that is the chain of command that I would go with. And you really should not rely on this. Sometimes there are multiple people in the same class who disagree. So you really want to actually think about who you would want to name and then go ahead and appoint that person. So how do you choose your healthcare agent? You really need to choose the best person for the job. Don't just name all of your kids if some wouldn't follow your wishes or if they don't get along. That's just, again, asking for kind of making a bad situation worse. So people sometimes have concern over the location of the agent. I mean, that is a factor, but generally people can serve even if they aren't local because of, we have so much technology that enables anyone, whether they're in, a different country, to step in and serve as your agent. So really what we always recommend is choose the person you trust to make your medical decisions that you would make if you were given the choice. So it's just someone who you've had these conversations with, you trust to make the choices that you would make, and that the person will not substitute their judgment for yours. I had a client who, would choose either of his kids, but his one daughter, when he had the conversation with her, specifically said, I could never do that. I would not be able to follow your wishes. And so they had the conversation, and he ended up appointing another child. And it was something they both recognized. She wasn't a good fit because of her own feelings and beliefs on certain things that differed from the parent. So that's why you have these conversations. Don't assume that you're on the same page if you haven't had the discussions. And then always have a backup agent. There's various reasons why a primary agent can't serve, whether it be death, their own incapacity. Maybe they're just really busy in their own lives or having their own personal medical issues. So you really should choose a successor or multiple successors. You can have co-agents depending on if they get along and would work well together. So a lot more goes into choosing your agents than just, I'll just name all my kids. So it's something to really think about and assess who is actually the best person for the job. Slide 17. Uh, this week, I've kind of already touched on adult children having a disagreement. Again, everyone can truly have the best of intentions and believe that they're doing what a parent wants, but not be on the same page. If the choices are in black and white, you have the document, there is no question, and that just makes it a lot easier for everyone. I'm going to pause for just a second. Allie, are there any questions?
We just had the question, just to repeat the website that you had recommended.
Okay, I don't have the actual website, but the if you Google, it's called the Conversation Project. It's like a nonprofit that specifically deals with having these conversations. And they always say, which I think is it's stuck with me, they say the place to have the conversations is around the kitchen table and not in the ICU. So I always think about that and, have these conversations now before it's an emergency situation. So again, the if you Google it, just Google the Conversation Project. Okay. Next, when do these documents actually take effect? Your healthcare agent can only make decisions if you are unable to make your own medical decisions. So I understand it can feel uncomfortable naming a surrogate decision maker, but you are not giving up any of your own abilities to make your decisions, your medical decisions. So you name this person, they have standby authority only. They can step in only when a doctor determines that you're unable to make your own medical decisions. The living will is when you are end stage medical condition, so death is imminent, unavoidable, or you're permanently unconscious, and again, and cannot make your medical decisions. So, like I said earlier, you can be end stage, but if you can communicate your wishes, you can continue to make those choices, and it doesn't matter what your living will says. Um, Healthcare power of attorney, it's really not just for older adults. Everyone over the age of 18 needs these documents. We are doing more and more young adult document sets where someone turns 18, you need a financial power of attorney, you need a healthcare power of attorney and living will. Medical issues can happen obviously at any age. And then now, a child, turns 18 and the parents notice a change, all of a sudden you can't log into their My Chart or whatever um, patient portal they have. You can't get any information from treating doctors. So young adults whose parents are still very much involved, especially, you can turn 18 and still be in a high school, or you're 18 and you're going to college. And so it's really important that a young adult actually gets these documents so the parents are still able to get the information, or in the event that the child can't make their own medical decisions, it's easier for the parent to step in and handle. So we really encourage even very young people to get these documents. In real life, I know probably everyone here, when you go to the doctor's office, you're asked and you're filling out your questionnaires prior to seeing the doctor. Do you have a healthcare power of attorney? Do you have a living will? When you have these documents, we always give our clients a digital copy as well. It makes it really easy. You can just upload the documents right to the patient portal. So if you see all your doctors at Mainline Health or Penn or wherever, everything's there. Now all of your doctors have it. So it just makes it very convenient to just have these documents as part of your medical records. Again, sometimes people feel uneasy having the living will be a part of their medical records, or having the appointment of their healthcare agent. Again, it's only relevant when you are unable to make your own medical decisions. So there's no harm in having those documents available to your doctors. Having these documents on file also has the potential to improve your care, because there's clear documentation about your wishes. There is a named decision maker, and there's consistency from a doctor's perspective in speaking with, the surrogate decision maker, versus if you have 4 kids and you haven't named anyone, and any or all of them can be involved. So it does help just kind of streamline your care. This is just about misconceptions. All of these are actually very common, but actually the one that I talk to clients about a lot is, oh, my family knows what I want. And that's just so often not true. You assume that you've either had these conversations or it's so obvious that they will know, but you really shouldn't assume that. I mean, so often when clients actually start to talk about this, there are surprises. Like I said the story earlier about the daughter who said she couldn't serve because her beliefs were so different. You really just need to actually spend the time and have the conversation. Um, how these documents fit into your estate plan. So everybody knows you need a will. So people come in and say, I need a will. And then I ask you, do you already have a financial power of attorney? Do you have a healthcare power of attorney? Do you have a living will? And the answer is no. These are important documents for your overall estate plan. Not only is it so important to plan for what happens to your assets when you pass away, it's also it's just so important to plan for what's going to happen during your life if you're not able to make your own healthcare or financial decisions. So it's really part of the complete package of making sure everything is handled. Again, if you've gone through the trouble of creating a will, you're already halfway there. You're thinking about what you want to happen. You might as well finish it out and just make sure that your family is taken care of in terms of everything is decided, and it makes it a lot easier for them. In terms of actually getting these documents, always recommend you work with a lawyer. Online documents, every day I see online documents that are problematic. There's something done, something is not right. So it's something to get done now and get it done right one time, so you can feel confident that the documents will actually work when you need them to. Otherwise, what's the point? So I recommend, if you don't have it, if you don't already have these documents, now's the time. It's not too late. If you do already have the documents, You should review them every time there's a major life change, such as marriage, divorce, other family changes, such as a diagnosis. Maybe the person you named as your surrogate decision maker is no longer the right choice. Or sometimes people do these documents when their children are very young, not look at them for decades, and then they look at them and realize, oh, well, when I did this, my child was 4, but now my child is 35, and I'd actually want that child to be the surrogate decision maker and not my neighbor from 30 years ago. So, pull them out, make sure that they are still, applicable to your life and your situation. When you do this when you get these documents done, you want them to be easily accessible. Like I said, you can upload them to the patient portal. Make sure your agent knows where they are or has a copy. Again, hopefully you've had the conversation with your agent, so there's no surprises. Your agent knows that they are appointed as your agent and understands your wishes. That leads me into the next slide, that families should know who is the decision maker, where the documents are, and what your wishes are. So have the conversations before you do the documents. You don't want the person you're naming to actually be surprised that they're named. So if you take the time to do the planning now, again, I get it. It's not everyone's idea of a good time to think about these hard things, make decisions between family members. But you truly are taking the burden off your family members or your friends or your surrogate decision makers. If you don't do the planning, you're just setting your family up for guilt, conflict, uncertainty. So I really hope from today's session, I'm happy to answer any other questions, but I hope that just from the last 25 minutes, you understand why these documents are so critical, and they're truly some of the most important documents you'll ever sign. Allie, any other questions?
Yeah, it doesn't look like we have any questions. Thank you,
All right.
Becky.
All right. Well, thank you so much for being here today, and I hope that you are on your way to either updating or getting a set of these documents.
Great, thank you. Thanks everybody for joining today. We also want to invite you to our next webinar on May 21st. That will be a topic on veteran benefits. Keep an eye out for an invitation to register in the next week. Thanks again, and we hope everybody has a wonderful rest of your afternoon. Thank you.
Bye.